A very good evening to all the participants and the respected resource person, Dr. Gargi Chakrabarti, ma'am. Ma'am, actually, GB Reddy sir was to join the meeting, but due to some unexpected meeting in the administrative building, he is unable to join now. He will be joining by the end, ma'am. I hope it is okay, ma'am. Ma'am, you are not audible, ma'am.
Yes. Irfan, I just want to know how long I have the time.
Up to 1 hour, ma'am.
Okay.
So for the benefit of the participants, we will have a brief introduction of the resource person. Dr. Gargi Chakrabarti, ma'am, is an associate professor of law at Dharmashastra National Law University, Jabalpur, MP, and earlier madam was with NLU Jodhpur. Madam is a postdoctoral research fellow at Max Planck Institute of Innovation and Competition, Munich, Germany in 2020. She was awarded Ph.D. from NALSAR University of Law, Hyderabad and M.Phil from NLSIU, Bangalore. She has done LLM in International and Comparative Law in IP Law from London Metropolitan University, London, UK. She has more than 14 years of teaching experience and research experience. Madam is also a tutor for WIPO Academy and completed 4 distance learning courses successfully. She has more than 40 international and national publications to her credit. Her achievements include IP expert for PIC and member of Rajasthan State IP Council, DST Government of Rajasthan, technical expert for QCI-NBA-UNDP Access and Benefit Sharing Scheme project for developing certification criteria for ABS scheme in 2021. Project on ABS mechanism in Rajasthan with UNDP, Government of India, NLSIU in 2018. And 13th Colloquium for Teachers of IP organized by WIPO and WTO in Geneva in 2016. Madam is also a visiting scholar to School of Law, University of Washington in 2015 and University of Washington Google project on intermediary liabilities on hate speech and child safety. Madam, it is a privilege and honor to have you with us as a resource person for the online lecture on the topic of WIPO Treaty on Intellectual Property, Genetic Resources and Associated Traditional Knowledge 2024. Thank you, ma'am. Now I request you to kindly address the participants.
Thank you, Irfan, for your kind introduction and thank you for the invitation. It's my honor to address the big gathering on this important issue. It's a burning issue for quite a long years. And thank you, Reddy sir, for considering me again for the resource person. Thank you, Osmania University. Now, the thing is like that. Let me start with some introduction. Then I'm coming to the recent legal instrument of WIPO. So the WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore, which is also known as Traditional Cultural Expression, was established in 2000. Now, WIPO member states and observers to discuss and address the intellectual property issues that arises in the context of access to and benefit sharing of genetic resources. Based on obviously the traditional knowledge, traditional cultural expression. Now, since 2009, WIPO member state have been negotiating this legal instrument, international instrument, which can ensure the balanced and effective protection of genetic resources, traditional knowledge, and traditional cultural expression. So for that, WIPO open the participation from all the member states. That's why the intergovernmental organization, non-governmental organization also joined hand with the WIPO. Permanent observer to the WIPO specifically accredited to the IGC, means the intergovernmental organization. So the discussion began. We know from first session to the 47th session, it was continuously discussing. We are eagerly waiting for when it could be finalized, because long years, so since 2000 to 2014, 24 years actually. In the meantime, the working group and most expensive discussion, some lately some definitive definitions came. I'm coming to all of this gradually. Now, I mean, all the discussion, observation, decisions, all these things discussed in a proper manner, and their views in accordance with the WIPO general rules of procedure. Even the IGC include many representatives of indigenous people and local communities. Now, indigenous peoples and local communities in particular need to be able to participate, express their views, and have their voices heard in the IGC decision-making process. And with that, 2007 United Nations Declaration on the Rights of Indigenous People as the outcome of the IGC negotiation will affect their rights. And WIPO started a voluntary fund also to enhance and support the participation of indigenous peoples and local communities in the work of the IGC. Voluntary contribution fund for representatives, observers who represent indigenous people or local communities, actually set up in 2005, and they can nominate, all the communities, they can nominate the representatives for funding by the WIPO voluntary fund. In this manner, they have started, and then gradually we reach today. It's actually happened that diplomatic conference to conclude an international legal instrument relating to intellectual property, genetic resource, and traditional knowledge associated with genetic resources. So somehow folklore and traditional cultural expression is not there. But another aspect, we know that primarily the traditional knowledge and genetic resources. And third component was traditional cultural expression. So May 13 to 24, 2024 WIPO Treaty on Intellectual Property, Genetic Resources and Associated Traditional Knowledge. Now the thing is like that, before coming to that particular treaty, we need to understand some basic understanding. Now, why the question arises, why we are trying to connect it to the intellectual property. Now, at the very starting moment, we have to be clear, because many of you can think, how come IP? Because public right, private right dichotomy was there, is there, correct? So it's a community right. Conventional IP, whatever we are thinking of, trademark, copyright, patent, industrial design, these are private rights, correct? Either legal person or natural person is holding that particular right. Geographical indication is a community right, and this particular genetic resources and traditional knowledge, that is also community right. So these are public rights. Then how come we can fit? So that was the one important discussion, how we can fit under IP. Now the thing is like that, forget about this definitive terminology or subject matter of intellectual property for typing for a second. Just think philosophically, intellectual property word. So what is intellectual property? So intellectual property means the property we can get from any intellectual contribution. Correct. Some intellectual contribution is there. Then we can say it is intellectual property. So in that sense, it is very easy to say it's intellectual property. Forget about, as I told, for a second, just forget about our typical standard understanding of IP subject matter. Correct? Now, this is there. Now, the thing is like that. Now, question arises, intellectual property, now coming back to our standard understanding, of IP subject matter, trademark, copyright, patent, industrial design, all this subject matter. Now, IP, all this subject matter, registered or unregistered, because we have the concept of registered trademark, unregistered trademark, registered industrial design, though India is not having, but UK is having unregistered industrial design. So here we can see that we are having the concept of criteria. So when the criteria is fulfilled, then only we are giving the registration. So someone is applying, and then the particular office is based on that particular criteria, we are judging. So whenever it is fulfilling the criteria, it is getting the registration. Okay. So another concept is clear. So philosophically, we can easily say that it is intellectual property. Second point, if we are thinking cliche, standard intellectual property understanding, then also we need to fulfill the criteria of that particular subject matter. Okay. Now, let's stop here. Okay. Just, we are now, I'm just going to give you one particular question. Okay. And I'm looking for some answer from the audience. Now, whenever it's an intellectual property protection, correct? So whenever we are talking about IP, whenever we are talking about giving IP, what is the meaning? You're trying to protect your rights, intellectual property rights, correct? Now, when you are trying to have it, why? My question is why? Anyone? Please feel free to answer. Why? Why we want to, please. Sania, or I have misplaced that particular name. Please answer.
Protect our invention. They are writing their messages in the chat box, ma'am. They do not have their microphone enabled.
Okay. Yes. So, okay, to protect our invention. But why you want to protect? Question is why? Plain and simple answer. Okay? Plain and simple first answer, that if I'm not going to protect it, there is a threat of misappropriation. So if I can protect, then I can stop someone to misuse or misappropriate it. First and foremost, this is the reason. And second, is the reason recognition. Who is invented? Who is behind this particular IP? Just now I told the intellectual contribution. So that particular contribution coming from whom? A university team, a company team, a particular individual. Who is behind that? Okay, so we are recognizing or acknowledging that particular person. Correct? So this is the two reasons we are trying to have the protection. First, to stop misappropriation, because there is a threat of misappropriation or misuse. We want to stop that. And second, we are looking for the recognition and acknowledgement of that particular contribution. Clear? Okay. So now the question of why we want the protection, we got that. Correct? Now we are going back to my previous point, that IP linked with this particular subject matter. Correct? Now, whenever IP is linked with this particular subject matter, as I told you, that it is a criteria based. Now, the thing is like that. Of course, I'm not going too far historically, because the concept of IP historically long back, it's not a new. But we know that Paris Convention, Bern Convention, Rome Convention, IPIC, means the Washington Treaty, all these based on different subject matter, we had the concept of patent, trademark, industrial design, appellation of origin, all these things already discussed, one definitive structure, provisions given. Okay. Then 1995, WTO came with TRIPS. It's not like that TRIPS given birth of IP. No. But TRIPS did one thing, that is the mandatory pressure on each and every WTO member country to adhere with this particular multilateral treaty. The pressure. This is the minimum basic for intellectual property, and you have no option. If you want to do the world trade, if you are a WTO member country, you have to follow. There is no option. Mandated. Okay. So this is the thing TRIPS started. And we know that different developing countries specifically, we had good lot of changes, amendments according to the TRIPS, even in India. So in this manner, we actually accommodate TRIPS. Okay. So the provisions of each and every subject matter of IP, if we are now giving the standard, as I told, the basic standard, if we are giving to the TRIPS, based on that, we are doing that. Now, that is why IP is a global subject. So you just heard that I'm a WIPO tutor. So I have a student around the world from different countries. How can I teach? Because it is not based on the Indian Act. Okay. So it's, I mean, IP is such a subject. If they know the IP, it's, anyone can deal with, because basic is the same. It's a global subject. Correct? Now the thing is like that. Based on that, we have started the game. Now the problem started. Now again, I'm going back to my why question. Why we are looking for the protection. Okay. Hope I'm not jumbling too much to make you confused. So the thing is like that. Now we got that from where we are standing on a same platform that I just want to establish. Now we are going back again to the why question, why we are looking for the protection. So first and foremost, I told what? the misappropriation or misuse. So one after another, we have seen the cases of the misappropriation. And it's a huge number. It's not only India, African countries, Latin American countries, including Brazil, all are somehow faced one after another undue patent application based on the traditional knowledge and genetic resources. That was the literally a problematic situation. Okay, so we know that our age-old neem case, turmeric case, there are so many, banana, wheat, ashwagandha, there are so many cases. Other cases we know little bit, not too much, but neem and turmeric case we know. Now, in case of Udia, Kamu, there are so many cases. Okay, so mostly developing countries were literally threatened by these undue patent application from Europe, from Japan, from US, mainly US. So this type of cases come up one after another. Okay, so based on that, we had some proposition. Now, already for the biological resources or genetic resources, because India mentioned the terminology biological resources, genetic resources and traditional knowledge, already 1992 CBD formed, correct? Convention of Biodiversity. So CBD also started given the sovereignty right to the biological resources or genetic resources. Article 8J talked about the protection of traditional knowledge. Again, Bonn guideline given us a specific structure, the competent authority, a structure, and ABS mechanism, access and benefit sharing mechanism to protect this particular thing. As I told, it's a public right. So somehow fitting into the conventional IP was the question. Okay, it cannot be the question. I'm coming to that. Let me just clarify some. Otherwise, it could be much more complicated. So one after another, I'm coming to the this particular understanding. So the thing is like that, well, basmati rice case, here it is genetic resource based case, but it is not really related with genetic resources and traditional knowledge. Somehow we have done, now basmati rice is protected as a agricultural goods in India under geographical indication. Okay, so as such, we are not considering the basmati case. True basmati is the saga. Okay, so just I have seen the chat box, so I'm giving that particular answer. So the thing is like that, what happened after all these cases, already CPD given one particular structure. Now, with all these particular cases, WIPO also in the year 2000 started this IGC and talking about that they bifurcated traditional knowledge plus genetic resources and traditional cultural expression. So in this manner, India is a signatory country of CBD, Convention of Biodiversity. Accordingly, we have National Biodiversity Authority. Accordingly, we have Biological Diversity Act, which is also fulfilling this particular treaty also. I mean, there is as such no need of doing extra work for India, because already we are quite legally, textually at least, we have already done our part. So in this manner, the one particular ground was there. Now, 2, 3, 4. CBD is talking about that. Later on, 2010, NAGWA protocol came, which is mandatory in nature. Though the mandatoriness of TRIPS and NAGWA protocol is hell and heaven difference. US is not part of that. Even US is not part of this WIPO treaty as well, where the maximum misappropriation happened. So the thing is like that, this particular forum, different forum is actually having this particular discussion. Now, as I told, here we are connecting with IP, and TRIPS is the minimum basic. Now, Brazil, India, Argentina, ARIPO means African Regional Intellectual Property Office. So, we together told, see, we need some changes which can solve our problem in the TRIPS. What are they? First, Article 27 is talking about the patent. So, Article 27(3)(b) is talking about the non-patentable subject matter. So, let add Article 27(3)(c) and mention specifically that like our Section 3(p) of Indian Patent Act, please mention that traditional, genetic resources associated with traditional knowledge is non-patentable subject matter. Like mathematical formula, like medical, surgical methodology is not patentable, scientific law, not patentable. So in this manner, give it as a non-patentable subject matter. That is the one demand. Second demand, Article 29, because here we are talking about Rakesh Kumar Baroi raised the hand. Irfan, what to do with? Irfan? Okay.
Yes, madam. Yes, madam. Yes, madam.
Rakesh Kumar Baroi, he has raised the hand. So can I take your question bit later on?
Yes, ma'am. We will have a Q&A session following the lecture, ma'am.
Yes. So please,
So that there is no.
Note down your question. I will give you all the answers.
Yes, they can
Please.
post the questions in the chat box as soon as they have it.
Yeah, have patience. I'm going to give you the.
Thank
So
you, ma'am.
the thing is like that. So we proposed. Now we know the step for the patent application. Correct? So whenever anyone is applying for the patent, first we judge it is coming under non-patentable subject matter or not. If it is not coming under non-patentable subject matter, then criteria, novelty, inventive step or non-obviousness, commercial application we judge. And of course, another criteria is the clear, unambiguous disclosure, patent specification. So clearly, unambiguously, we need to give the disclosure of the invention. So Article 29 of the TRIPS is talking about the disclosure. So it is already there. But specifically, all these countries, specifically Brazil, India, Argentina, and all other countries, developing countries, we told, let's introduce Article 29 bis. And specifically mention that country of origin. So if your invention is based on the traditional knowledge and genetic resources, just mention from where you have collected those genetic resources and traditional knowledge. Okay, so in this manner, there was another proposition. Now this is the pending issue before the TRIPS for a quite long years. Okay, so there is no nothing like that happened. Okay, and as I told, desperately we are waiting for the WIPO IGC. How much it will be effective, we will see later on, but it's a good try. It's a burning issue because, as I told, that is why I have started with the why. So the protection is very much needed. Now, in this context, I have given, because I have just mentioned of the disclosure of origin, I'm just giving one example. There is a patent, till now a patent, on what? Brahmi, active ingredient. Now we know that Brahmi is a very effective Brahmi leaf. Now what we do, we actually take the extract from the Brahmi juice, or as a medicine we use for the memory enhancement, for the sleeping disorder we use that. Now we never into the active ingredient, the reason behind all this memory enhancement or sleeping disorder rectification, what chemicals is working, we never figure it out. We know it from our traditional knowledge, this Brahmi leaf extract is workable, fantastic medicine, and we use ages. Now what happened, one US company, they actually figured out the active ingredient of this particular chemical, and they got the patent on that active ingredient, but there is no mention. Now my point is very simple. My point is, why Brahmi? Why you try to figure it out, the active ingredient of Brahmi? You can easily have the anything else. So let enter into the forest and take A, B, C, D, whatever maybe the plant you are getting, and start getting the effect or impact of each and every leaf. No, you are not doing. Because half of the work, or more than half of the work, has been done because of the India's age-old traditional knowledge and genetic resources. You know, the result is quite certain. That is why the active ingredient of Brahmi you figured out, and you got the patent. Without any disclosure of origin, it is coming from India, and the traditional knowledge also coming from it. So 29 bis is also somehow pending, long time, this basically pending. Now in this line actually we have this particular treaty, as I told, WIPO Treaty on Intellectual Property, Genetic Resources and Associated Traditional Knowledge, which happened in this May 2024. I'm just going and exactly reading the objective of this particular treaty: enhance the efficacy, transparency and quality of the patent system with regard to genetic resources and traditional knowledge associated with genetic resources, and prevent patents from being granted erroneously for invention that are not novel or inventive with regard to genetic resources and traditional knowledge associated with genetic resources. So you can well understand from that particular objective our why. Correct? So erroneous patent or undue patent needed to be stopped, or which is credible patent. After judging that, we can give that particular patent. That is the thing established in that. Now the point is, here there are some terms also mentioned. Okay, so applicant, application, contracting party, country of origin of genetic resources. Just now I have given that understanding also. Based on means that the genetic resources and or traditional knowledge associated with genetic resources must have been necessary for the claimed invention, and that the claimed invention must depend on the specific properties of the genetic resources and or on the traditional knowledge associated with the genetic resources. Correct? Now, genetic material, genetic resources, more or less from the CBD also we got that particular understanding from that point of time. Disclosure requirement, explicitly Article 3 disclosure requirement mention the country of the origin of the genetic resources, the claimed invention in the patent application, based on the traditional knowledge associated with the genetic resources, they need to disclose the indigenous people or local community as if it is applicable. Now, hypothetically, I am saying where we are standing. Now, the thing is like that, as I told, that in the line of, though our Biological Diversity Act came 2002, 1992 CBD came and we are the signatory country of CBD, and CBD MON guideline given that particular structure even. And Biological Diversity Act is having that Section 6 of Biological Diversity Act. Section 6. Now, under our Biological Diversity Act, there are 5 types of activities. Number 1 is the commercial use of genetic resources and traditional knowledge. Okay. Second one is the transfer of result of any research, genetic resources and traditional knowledge. Third, transfer of material, genetic resources and traditional knowledge. Fourth, intellectual property related with genetic resources and traditional knowledge. And 5 is only research. So this type of 5 activities. For these 5 activities, specific form is there. So we have the structure, that competent authority, National Biodiversity Authority, under that State Biodiversity Board. Under State Biodiversity Board, BMC, Biodiversity Management Committee, which is the grassroots level, the local community, the indigenous community, they are. So it can be a village based or block based. In this manner, the BMC, Biodiversity Management Committee. So this tertiary or 3-step structure is there to control that particular thing. And it is based on access and benefit sharing mechanism. Now, what is access and benefit sharing mechanism? Very simple. Now, the thing is like that, I need one pen. Just one example very quickly. I need one pen. And I asked, so Irfan is having that pen. I can.
Yes, madam.
That pen. Okay. I can. Yeah, no, nothing, Irfan. I'm just taking your name to give the example.
Okay.
So I can snatch from hand. That does not look nice. Snatching from his hand without asking. Now it's good if I'm asking the permission from Irfan. Irfan, can I take your pen? Now Irfan can ask me some question. Ma'am, this is blue color pen. Do you need a blue color pen? Or do you need black or red? How long you need? For 2 days, for 3 days, for 1 week, for 1 month, or forever? He can ask that question also. When it is clarified, first, in a gentle manner, ask his permission. And then when he agreed, and I'm clearing all this question of Irfan, then only I can access his pen. And after utilizing his pen, when I am returning that pen, I can give a big thank you to him. Or plus, not or, plus, I think chocolate is liked by all. Let's give a chocolate bar to Irfan for giving me that particular pen. Hello, Irfan is not liking chocolate. So if I'm giving the chocolate without knowing it or without asking Irfan, it's not acceptable. So it's better for me to know that what is the thing Irfan could like it. So this is the access and benefit sharing mechanism. PIC, prior informed consent. So before access, I need to take the prior informed consent. Then access. How long? What is the quantity? For what purpose? Research purpose, commercial utilization. All these clarification, the access. And then the benefit sharing with the mutually agreed terms. If one loves laddu, why should I give him the chocolate? I should give him the laddu. That is the mutually agreed term. So in this manner, the structure of the access and benefit sharing mechanism. Even Section 6 of the Biological Diversity Act is talking the same. If any intellectual property or if any invention happened based on the genetic resources and traditional knowledge, whenever any application is getting by anyone to the patent office is sending to the NBA within 90 days. It is going to be checked. Checked for what, basically? Of course, they are not the person or expert for the patent. They are not examining the patent. But this form must be filled. This ABS, as I told, for this 5 activities, specific form is there. Of course, there is a 2-part. One is the foreign entity and one is the domestic or national entity. For foreign entity, it could be directly to the NBA, and national entity, that is going to the State Biodiversity Board. But for IP, whoever entity, foreign or national, that must go to the NBA. NBA is giving the green signal, and then the examination start in this manner if the invention is based on that. Okay, now I know few examples of this type of invention got the patent. One example is it's like a custard apple type of fruit, annona. So this particular fruit, from that particular fruit, they make the pesticide. Okay, and PVC type of pipe made from the pineapple leaf fiber. So this type of invention cleared by the NBA and got the patent also. Now our Patent Act, now it's very appreciable or very much good initiative from the Indian government that India, Brazil, Argentina were together for a long years, continuously working or talking on that particular thing. And accordingly, even our Patent Act is very well equipped. Just now I told we actually talked about Article 27(3)(c). We proposed that for the non-patentable subject matter. In that line, India is already having Section 3(p), where traditional knowledge, genetic resources associated traditional knowledge is non-patentable subject matter. Pre-grant opposition, Section 25, post-grant opposition. So here there are certain pointer on what ground the pre-grant opposition and post-grant opposition can come. A specific mention about this particular disclosure, and this type of patent is having a specific pointer provision that it is not allowed for the patent. So what India claimed internationally, what India literally worked for or raised the voice, in the same manner our Patent Act accommodated all these things long back. We have all these things. That I just want to tell. We are part of this treaty because, as I told, that India worked, like WIPO is working really good on that. African Regional Intellectual Property Office. Not only ADIPO, Argentina, Peru, all the Latin American countries also working really good. As you know that I went for the WIPO WTO IP Teachers Colloquium. So 29 countries represented there, and all are coming from the developing country. So seriously, I know that how much Africa and Latin American countries are serious about it, and they're continuously. It is available on internet. You can easily get those. So in this manner, so the raised voice is already addressed. So what today WIPO given a conclusion or the way to do that. Now the point is the misappropriation from where it is happening. If it is not addressed in those countries, then it is somehow problematic to some extent. Just a moment.
Yes, madam, is there any issue?
No. Just a second. Irfan, can I share the one PPT with you?
Sure, ma'am.
Thank you.
If you send it across, I will share it from my end, ma'am.
No, I get it. It is visible?
Yes, ma'am. Yes, it is visible.
Yeah. So the thing is like that, as I told earlier, that this 5 invention must related with the patentable subject matter, new its novelty, inventive step, and industrial application, and in detail specification must be disclosed. Now this section specifically, section 3P is very much the non-disclosure, pre-grant and post-grant opposition, and 64 is the revocation. All these mentioned. Now section 6 of the Biological Diversity Act, National Biodiversity Authority, approval before the patent application, that is there. And section 19, proper inquiry by the National Biodiversity Authority and consultation with expert committee, that's there. That particular form is.
Ma'am, the slides are not changing, ma'am.
Now it is changing?
Yes, madam, it is changing now. It is not
Okay.
visible in full screen, but
When I'm doing the full screen, it is not moving better.
okay, ma'am, no problem. This is fine.
Okay. So the thing is like that. One particular thing I just want to show you. Yeah, sorry. Okay, as I told earlier, it's not about the only the turmeric and neem case. Now, Avon Cosmetics case. Okay, so here also, examination, the examiner's comments in the examination report, 2014 TKDL submission in the context of patent application. So the thing is like that, it is totally based on that the extract they have taken from some turmeric and some other genetic resources, and they use that particular, and primarily European Patent Office given that particular patent, and later on from now you know about the TKDL, correct? You have idea about the TKDL. So what happened after the turmeric case, if we are just going to discuss about that. Now, US, Canada, some country, they are totally based on the documented. So if you want to give the opposition, you have to substantiate that opposition through the documented something. So you need to substantiate the case. So oral knowledge is not really accepted by them. So when we went for the opposition of the turmeric case, we have taken the Manu Sangita, Ramcharitmanas to show that it's for ages that we use the turmeric as a wound healing property. I mean, I'm just telling you one typical understanding or my own experience. So when I was pursuing my LLM, at that time, actually, the turmeric case came up. So one of my IP class, she is British, the Professor Even Smart. I mean, Indian cuisine is very famous in UK. You know that. So she suddenly told that turmeric, she thought turmeric is a coloring agent. So to make our curry colorful, we use the turmeric. She told in the class even that it's a coloring agent. And I told, sorry ma'am, it is not the coloring agent. We never put the turmeric just to make it colorful. It is having an antiseptic value. So that is why it is having the wound healing property and it is having the antiseptic value. So to make the food safe and for various other reasons, if our somehow if we have a sprain or for any injury, then also we put the turmeric. So haldi turmeric we use as a medicine. Haldi chuna we use on the swollen injury. So in this manner we use that. So this is the thinking process. I'm sharing my personal experience because this is the thinking process of the outsiders. So the thing is like that. Now, next one is the WIT case. Though it's again European Patent Office in Munich granted the patent to the Monsanto for a simple title, plant. Even though the plants were not patentable in the European law, the patent covered WIT exhibition a special baking quality derived from the native Indian wheat. With the patent, Monsanto held a monopoly on the farming, breeding, and processing of a large of wheat variety with low elasticity. Okay, so again, somehow it is we challenge this particular patent before EPO, European Patent Office. As I was telling the Ashwagandha case. So Natarion ANSI US filed a patent application 2006. Ashwagandha for treatment of stress, sleeplessness, anxiety. Okay, so this is the thing. Now I just want to show you one thing. I'm coming to the other cases, but I just want to showcase the TKDL, Traditional Knowledge Digital Library. So after the turmeric case, all the classic text of ours, like Charak Samhita, Shushruta Samhita, all the classic text, we started documenting. Another 5 language apart from English, it is available, and it is worked as a patent search database. Okay, so through the TKDL, now TKDL is associated with the as a patent search tool. So whenever any genetic resources and traditional knowledge is applied in any patent office, in the year 2020, I was in the Max Planck. So I really didn't know before that Europe appreciate, or Europe is, so much overwhelmed by the TKDL. So literally I heard from the professors and my other colleagues, other scholars, that they how much really appreciate that particular initiative by India, Traditional Knowledge Digital Library, as a patent search tool. Now it's an ongoing process. Now, don't take it as a what should I say, any criticism or something, because sometimes we need to say something to do much more better, or for further development is always needed. That is why sometimes we criticize. So take it in a positive manner. So the thing is like that, as I told, that 2010 our NAGWA protocol came. So NAGWA protocol even talked about the PBR, Public Biological Biodiversity Register. So whatever is coming under the classic text, it is already included in the TKDL. But beyond our classic text, there are so many. Each and every nook and corner of India is flooded with our precious traditional knowledge from different our communities. So each and every BMC, under the supervision of State Biodiversity Board, Public Biodiversity Register is there to note down all these local genetic resources and associated knowledge and holder community name. A typical register which is having 2-3 columns, and they need to maintain. And TKDL is an ongoing project, so TKDL can update time to time from the PBR. But I'm sorry to say that, as you know that I have worked empirically in the grassroots level, during 2 UNDP project, and the few SBB like Telangana, Gujarat, Maharashtra, to some extent MP, Uttarakhand, they are doing fabulous. Even Karnataka, Kerala, they are doing good. But most of the, I'm telling about the Rajasthan, where there is no BMC. I'm telling about the Bihar, there is no BMC. So grassroots level, interestingly, if you visit NBA website, you can see some number. That number, how come generated? It's a good question. And I'm telling from the ground, not the hearsay, not the any source. I know that I've done work in the ground level. So if what today we are seeing, the success story of the TKDL, that's why I'm sharing this particular slide, that so many filed on, the patent filed on, you can see the patent filed on year, the applicant, different companies, Israel, Netherlands, even Kenya, resources, Indian lotus, Bengal gram and chana, neem, dalchini, grape, apple juice, rose and sweet violet, bhang, orange, okay, and use for heart disease, obesity and diabetes, cardiotonic. So all these things used for this, and all are withdrawn 2009, 2010 because of the TKDL. This is the success story of the TKDL. So you can see Australia is there, Korea is there, USA is there, Switzerland is there. Even some our own struggling partner like Argentina and Kenya is also somehow there. So even within Southeast Asia, I have done one particular paper based on the Southeast Asia. There I have seen that other Southeast Asian countries doing the misappropriation of other Southeast Asian countries. So in this manner, we can see. Now going back to some more cases like melon extract to cure vitiligo. Vitiligo, whitening the skin, you know that. EPO decided to grant the patent coming from the Spain. And again, because of the TKDL, it is withdrawn. Banana, 2010, India again filed opposition for that. And you will be literally astonished by seeing that the whole banana fruit for treatment of mood disorder, reducing stress and anxiety, depression, increasing BMR, thermogenesis, obesity, hypercholesterol, hypertension, diabetes, sleeping disorder, neurological disorder, muscular disorder. So you can understand that what precious thing we are having with us. As I told, that each and every nook and corner. I'm sorry, actually, I have a power cut here, so bright light is not there. That is why I'm seeing in this manner. So this is the one thing we literally need now, because TKDL is an ongoing project and we really need to develop our PBR, Public Biological Register, Biodiversity Register, to enhance, to jot down, which is not coming under classic text. So to enhance our TKDL. And as I told, that EPO is taking it very seriously. It is used as a patent search database. So in this manner, we can really enhance this particular thing. Now I'm stopping here. If you can ask any questions, please feel free to ask questions, because some hand was there. Or Irfan, if you can give them access for the mic, they can ask directly as per your rule.
Yes, ma'am. Ma'am, like in our previous experience, it generally when we give access to multiple speakers,
Yes,
right,
yes,
speak at
yes,
the
yes,
same
yes,
time.
yes.
And
So
because the
yeah,
session is
chat
also being
box.
recorded, so in order
Yeah.
to maintain more,
So whoever is having the question, you can put it in the chat box, because some raise hand I have seen. So maybe you have some specific question, so I can clarify more.
So, good evening, Dr. Gargi. This is Professor G.P. Reddy.
Good afternoon, sir.
Very good afternoon.
Thank you so much, sir, for this invitation.
No. It's always a pleasure to, hear your presentations. And today also, you have been, in fact, up to date with all the latest developments with regard to the WIPO Treaty on genetic resources and associated traditional knowledge. And because you very appropriately established the nexus between the WIPO Treaty and the practice in India, especially with regard to the National Biodiversity Authority, the permissions granted so far for IPR purposes. I think it's more than 4,200, and TKDL more importantly. And I'm sure that our very loyal patrons, now there are 98 in the in fact group right now present in the meeting, online meeting. They have thoroughly enjoyed and enriched themselves. But we have one or two questions from the in fact the participants. There is one question from Rexy Shiba, and the question is this: is TKDL safe and secure in protecting our Indian traditional knowledge?
See, TKDL can be utilized in a, as I told, TKDL, we are utilizing it. One is somehow the database of the genetic resources, traditional knowledge and community. And we have started from the classic text that we started from all these classic texts. Now, we have just seen how many patent oppositions successfully we can oppose through the TKDL, because good many countries, they want the documented. So oral knowledge is not acceptable by them. So we need to substantiate. So TKDL is utilized as a patent search tool. So whenever any patent application is coming, the combination of genetic resources and traditional knowledge, then with the TKDL, they can stop what EPO is successfully doing. Now, in this manner, as a database also, we are somehow accumulating all those things. Otherwise, it is scattered. And second one, we are utilizing it as a patent search tool to stop someone from erroneous patent. Now, the thing is like that. See, the misappropriation happened previously also, we have seen. That's why I have given some more examples apart from turmeric and neem, that those, even I have mentioned about the Brahmi active ingredient, that particular case, it is still having the patent. Now, the thing is like that, this particular text or this particular things are available in the market. So why we are thinking that TKDL is not safe? TKDL is the ready hand remedy for them to know about the traditional knowledge and genetic resources. So that is why people can take the information from there and they can utilize that. If they want to utilize that, there are good lot of already flooded information already present, because those are already published. They are in the market. So if they want to gather those knowledges for the genetic resources and traditional knowledge from other sources also, they can get those knowledges. So misappropriation happened. Misappropriation is happening, and misappropriation to some extent will happen. Now we are trying our best to stop that with some, so this is the tryout. So as I told, 2000 we have started, and 2024, 24 years we have waited, desperately waited. When the WIPO IGC is coming with this legal instrument, So we need to see how much we are going to, but it's a long struggle. It's a really long struggle to stop this erroneous patent. Now, even in this particular treaty, it is mentioned prior to that particular treaty, it is not effective. So retrospectively, it is not effective, but prospectively, it is effective, which is always there. Now, in this manner, I don't see for the creating the database for the traditional cultural expression, it's a pretty tough job. We can try, but it's a very pretty tough job. So that is why I think primarily also WIPO taken because the subject matter of traditional cultural expression is too vast. So there is the fable, folklore, painting, folk dance, folk songs, I mean recipes, what not we are having under the traditional cultural expression. So it's a pretty tough thing. So at least this initiative is very welcoming initiative. And as I told, India is already having the legal provisions, and in this line we are already working, and successfully we will work.
Yeah. I think.
But we have to invest our energy and time more seriously to do the PBR.
Correct. And I think that there are two other questions relating to the same, ma'am. One is from Kushi Kandelwal. It is about the TKDL and its scope in respect of biodiversity and folklore. I think you answered that.
Yes, sir.
There is one more query also regarding the same. Folklore being left out, from the
as
treaty.
I told, I mean, folklore needs time. It's very difficult.
That I think now we have to focus mostly on the associated traditional knowledge, because look at the title of the treaty: genetic resources and associated traditional knowledge. And here the biodiversity management committees have to play a very important role in India under the Biological Diversity Act. And now we understand that there are about 466,000 or 266,000 committees. So that's what I think the NBA says. Now, if that is the case, the role to be played by the BMCs and the PBRs, People's Biodiversity Register. Ultimately, this is the law in action, and that needs to be focused in order to
yes, sir.
Derive
As I told, I have worked in the ground level for the 2 UNDP project, and what I have seen, some state is working fabulous, but some states, out of 29, maybe not even 9, they're working so good. And some are literally silent, sir. They're not working anything. As I told, sir, Bihar, Rajasthan, they're not having any BMC. It's a zero BMC, sir. And somehow. Now, another problem is in this particular case, sir, it is somehow related, as per section 6, it is related with the IP office, patent office. Now, Biological Diversity Act is coming under the MOEF.
Right.
So, Ministry of Environment. So, DST, which is taking care of IP, whenever you start talking with them, they used to say, ma'am, biodiversity, that is related with the Environment Department. So, there is a department-wise also Environment Department and Department of Science and Technology, the IP. So, that coherence also we very much need, sir. Because it's a combination of two.
In fact,
that is
I think
also very much needed.
This gives us an opportunity to rethink on our strategies to protect IPRs from a holistic purview. Because I think after the abolition of IPAB, then in fact once upon a time, you may recollect, Dr. Gargi, that different IPs were under different ministries. right? Copyright under HRD.
Yes, sir. Yes, sir. 2016, because sir, I was the IPR-Chair coordinator under MHRD.
Right.
So I precisely remember 2016, there was a shift from all the IPR chair and then DIPPIT and then this, yes, sir, all the subject matter. Now, this particular thing, we need a very good coherence, sir, that Ministry of Environment and IP. Because I have faced in a practical, when I worked on that, I faced that. They actually used to shuffle us between IP department and environment department. So this is the one thing.
Yeah, and I think now time has come for DPIIT on one hand, that is under the Ministry of Industry and Commerce. Then again, MOEF on the other hand, which is taking care of the forest, biodiversity, so on and so forth. And maybe even, the other line departments, to come together and ultimately, deal with this new opportunity in order to, in fact, ensure that the associated traditional knowledge that is associated with the genetic resources is protected. And again, probably new focus should be even on ABS now. We're talking about access and benefit sharing, which is a forgotten area. Except on paper, we don't come across any successful stories. In many cases in India, some failed attempts. Fine.
Sir, I'm just sharing just 2 minutes, sir. Sir, there was a project I worked on 2021. That is the QCI, Quality Council of India, NBA and UNDP. And I was an external expert there. So we try to give, if any Indian company is selling any product who are adhering with the ABS mechanism, so they can get some sort of mark, like eco mark or something like that. They are going to. So QCI, so I actually developed that compliance. And there was a big discussion among all these. I'm not naming the companies. You can well understand the companies who are continuously using the genetic resources for their toothpaste, for their cosmetics. So we had a huge meeting. It's a day and night work. Sir, you can't imagine we are somehow successful to stop the erroneous patent through the TKDL. We are successful to some extent to get the ABS from the foreign entity, but it is very difficult to convince the national companies for the ABS. On our face, they told, why should we? We are already giving the taxes. We are already giving all those things. We are the Indian citizen. Why the extra burden on our shoulder to go for the ABS?
Correct.
Sir, I am not naming anyone, but this is the thing. And they don't bother about TKDL also.
Right.
So this is the ground reality I have faced. I was furious. I literally lost my temper for a time being. What are you saying? You are utilizing because you are putting the long, in the pest, because you know it is good for the teeth. It is from the traditional knowledge. That is why you are utilizing, you are advertising, you are promoting that also. So we know that, sir, Divya Pharmacy case, that some language is also in the Biological Diversity Act, we need to change, because for the section 7, there is a word is the consultation, not the consent. So they raised that particular Patanjali case, they raised that particular question. So there is a difference between consent and consultation. So little bit of this type of amendment also we need. But it is very difficult, sir. It is very difficult to implement in the national level.
Correct. Totally agree with you, ma'am. And maybe, this discussion today, triggered by you and very well explained by you, will prompt many of our participants to think on the consequences or the impact of this WIPO treaty and the steps to be taken by the national authorities, whether it is the legal steps or administrative steps, some kind of administrative reforms, and maybe changes in the structures to make complete use of the WIPO treaty and the flexibilities given by it. We have to only relook something, which is already being done, but I think streamline it. And then that was a fabulous presentation, Dr. Gargi Chakrabarti. It's always a pleasure to, in fact, hear you. And thank you so much.
Thank you, sir. Thank you so much.
Now I think our DPIIT chairs must come together, must plan at least, maybe a one-day workshop kind of thing, virtual or, in the physical world, maybe one day, maybe 2 days, and to discuss threadbare the various issues which you highlighted and the connected and incidental issues, so that maybe very useful inputs can be given to the ministry and the government. And this is one ambition I have, at least. I hope that all of you would join with us. Let us come forward and coordinate, collaborate, and do something.
Sir, anytime, sir. From my side, any contribution, sir. Thank you so much, sir.
Thank you so much. Thank you so much. And we also thank all our, patrons, 100 now at
Yes,
6:26 p.m. Because this is the reputation built by DPIIT IPR-Chair Osmania University since 2021, and our resource persons have been quite scholarly, practical, and our participants have been equally enthusiastic. And our website contains now as many as almost 45 to 50 videos, in fact, which we won't get anywhere. Even WIPO website will not have so many, and with those lectures delivered by experts, right from the administrators, Dr. G.R. Raghavendra, then Dr. K.S. Kardam, then number of, wonderful academicians and young and dynamic academicians like Dr. Gargi Chakrabarti, and many more. So I think the credit goes to all of you. Thank you so much. So,
thank you, sir.
Now I would like to request my colleague, Research Associate, Dr. Irfan Abbas, to propose a formal vote of thanks. Irfan, over to you, please.
Thank you, sir. On behalf of IPR-Chair at Osmania University, I would like to propose vote of thanks. First of all, we would like to thank Dr. Gargi Chakrabarti ma'am for immediately agreeing for this online lecture. Madam has been with us for the second time this time. Earlier also, Madam was very gracious enough to accept this lecture, giving assignment. Thank you so much, ma'am. We would also like to thank the participants for their continuous support, and also we would like to thank the DPIIT for sponsoring us, and my colleagues, Mr. B. Nagaraj, and also we would like to thank Shivavardhan Yadav and Miss A. Vaishnavi. We will again meet in the next session, and we request the participants to kindly fill the feedback form. Thank you very much.
Thank you, Irfan. Take care. Bye.
Thank you, ma'am. Thank you so much.
Thank you, sir.
Thank you, ma'am. Thank you.